Hi, my name is Randall McCauley. I'm CREA's Vice President of Government and Public Relations.
And I'm David Salvatore, CREA's Director of External Relations.
We're here today to talk to you a little bit about the new FINTRAC and anti-spam regulations that have come in the last 6 months from the Government of Canada. Just as a general introduction, the two pieces of legislation or regulation come from the same place. Marshall McLuhan talked about Canada or the world being a global village and communications linking us all together. In the same way, with respect to FINTRAC and anti-spam, fighting crime, corruption, the desire to take a global approach to both these issues is what's driving them. Canada is the only G7 country not to have anti-spam legislation, and there are currently about 100 countries around the world that have some sort of anti-spam regulation. With respect to FINTRAC, the responsibility dates back to the early or late 1980s in the United Nations, when governments got together and decided they needed to combat the sale of drugs and money laundering that went along with it. So the origins of the onuses that this may place on Canadian realtors or brokers comes from an international obligation to combat money laundering. The terrorist component of it comes from the 2001 terrorist attacks in New York. So both pieces of legislation and regulation come from the sort of same source, come from international, the desire to comply internationally or the desire to meet an international standard. So it was a matter of if and not when Canadians were going to be subject to both of these. And the purpose of the briefing today is to give you the information you need to be compliant with both right at the outset to save you time and effort. So the goal of CREA in both of these, with respect to anti-spam and with respect to FINTRAC, has been to reduce the compliance burden. And in both cases, as I've said, we knew that we were going to have to deal with some changes in the industry as a result of international obligations. And so our focus on the last 3 or 4 years has been to reduce the burden and make sure that any changes or modifications we got on behalf of realtors is to save time, money, or effort. So for that reason, there are two guides available on Realtor Link that talk about your obligations under anti-spam and FINTRAC. So today we want to talk about the broad strokes, the general themes of both pieces of legislation and regulation. We're going to start with FINTRAC, and then we're going to go right into anti-spam and take you through some of the changes and some of the details that you need to be aware of to be compliant with both sets of rules.
So talking a little bit now about a little bit more about the international context. These rules and regulations, they flow from the international body called the Financial Action Task Force, which is made up of 38 member countries, Canada, the US, a number of European countries. And what the FATF does is it does two things. One, it sets international money laundering policy that it expects member countries to follow. And secondly, it audits compliance with those policies. And that's really where these regulations that came into force on February 1st came from. It all originated back in 2008, an audit that was done of Canada by the FATF that found that our country was largely non-compliant on customer due diligence measures. And specific to real estate, found that the requirements were basic and limited. So the government was quite clear with us and other reporting entities and said that they intended to make changes to ensure that Canada is green lit at the international stage. So now that we've talked about global context, I'm going to talk now about local implementation and what it means for brokers and realtors in Canada. The new obligations really build on existing requirements. So if you've been largely compliant to date, what we're talking about is a few steps rather than a giant leap. They're all based around, these new regulations are based around the concept of a business relationship. And what that means is 2 transactions with a brokerage in 5 years. Now, before CREA began lobbying on this, the original proposal was unlimited. There was going to be no time frame, no 5-year time frame in terms of triggering the business relationship or in the expiry of that business relationship. So it's really important from a lobbying perspective that we put a time limitation so that's really what we fought on for a number of years. The end result is that there is a 5-year limitation, both to 5-year limitation around the concept of the business relationship. And once a business relationship has been triggered, once those second transactions occurred with a brokerage in 5 years, what it does is it triggers a number of additional obligations, collectively known as customer due diligence or ongoing monitoring obligations. And basically what this means is know your client. There are 5 components to this which we're going to walk through, and they are purpose and intended nature of the business relationship, client risk reassessment. There's been a long-standing obligation under FINTRAC to conduct assessments of client risk on the first transaction. What's being asked for in these new regulations is a reassessment of that risk. Keeping information about clients up to date, monitoring business relationship, and again, this is where we really wanted to ensure that it was clear and that there was a fence placed around it, and that the burden wasn't as great as it could have been. And also around IDing individuals who conduct attempted suspicious transactions. If you're familiar with FINTRAC, you probably are aware that suspicious transactions, there are a number of obligations already around suspicious transactions. And a large part of our lobbying and our focused on mitigating the practical implication of this through updated CREA forms. Initially, when we saw the regulation and the guidance around these the new FINTRAC requirements, we were concerned that there would be a lot of back and forth between the agent and the brokerage during a transaction. It was really important to us as we recognize that brokers have a limited view. They often don't see the client. Agents also have a limited view, but they deal more face to face, as you know, with the client. So it's important as we work towards implementation on this that it was possible to do in a one-way flow, and that's why you'll see as we walk through this how the CREA forms have been updated to make that work. So now we're going to talk about applying the new regulations, and this is just for business going forward as of February 1st. So the first thing you're going to ask yourself is, did your client conduct a previous transaction with the brokerage in the past 5 years? If the answer is no, then the old rules still apply. You still have to do a client risk assessment, you still have to do the IDing component, you still have to look out for suspicious behavior and then report that as in a suspicious transaction report. If the answer is yes, then the new rules, new requirements kick in. And the first component of that is around a purpose and intended nature of a business relationship. And what the government means by this is, in acting as an agent for the client, our brokerage is dealing with transactions that are they either residential property, are they commercial property? And as you can see from the slide, that's taken directly off the updated CREA form. This was a requirement that flows directly from the Financial Action Task Force, and we were really concerned at the outset this could have been implemented in Canada in a manner that was confusing, complex, and onerous. So we really focused on ensuring that it could be done very simply by the agent in a checkbox format, and that's the result that you see on the updated CREA form. The second component is around a client risk reassessment. As I mentioned earlier, there's been a long-standing obligation to assess client risk. Basically, what brokers are doing on a second transaction in 5 years is reassessing that client risk. At the bottom of the form, you'll notice, at the bottom of the slide, you'll notice that's taken directly from CREA's form, the updated CREA form. And what that is basically is it's a concept called clustering. It's one way that brokerages can meet the new requirements. Basically, what this means is putting your clients into specific risk baskets and then assigning a risk level to that. So for example, a Canadian citizen or resident physically present, if you believe as a broker that that's a low risk situation, you can keep that on your form, and then your agent would basically, when dealing with that situation, would check the box, provide it to you. You'd look at that in combination with the other information you have on your client on file, and either agree or update that particular risk determination. I should mention at this point that CREA has been working for a few months now since the regulations since the guidance was finalized around the regulations, around working to offer a automated solution. We're in the process of doing that, and we should have more information available in the coming weeks and months, but we're targeting the fall of this year to have that hopefully out to brokers. The next component is around updating client information, and what basically you should be looking at this as bumping into an old friend. So basically what they're asking is, has any of the information that you have on your client changed? Has their address changed? Has their occupation changed? Has their last name changed? If it's changed, you just have to update the form. You don't have to ask for ID again if you already have the ID on file and you don't doubt the veracity of that information. The fourth component is a term that they called ongoing monitoring. Now, when this first came out, we were quite frankly quite concerned what this meant. We were concerned that it could have meant following a client after a transaction and documenting certain things. We really focused on ensuring that it was tied to the transaction, and the end result is that customer due diligence just has to be done during the transaction. The other component is in terms of how to meet this. And again, we were concerned that this was going to lead to a mountain of new records. We really focused a lot of our discussions with government on record keeping rather than creating new records. And the end result of this is that you can keep correspondence with your client on file, and that will be enough to meet the test for non-high-risk clients. For higher-risk clients, for high-risk clients specifically, there's been a long-standing requirement to take additional steps. On the slide, there are some examples. Those aren't necessary, but you do have to have some steps in place that are tailored specific to your brokerage as to what you're going to do when your agents encounter high-risk clients. The fifth component is around suspicious transactions. As I mentioned earlier, there's been long-standing obligations around suspicious transactions and reporting them. What's new here is IDing individuals who conduct attempted suspicious transactions. There are two exceptions to this that I think are important to mention. The first is if you already have obtained ID and you don't doubt the veracity of the ID. And secondly, if you believe asking your client would tip them off that you're filing a suspicious transaction report, you don't have to ask for ID, but you need to document that. In fact, you shouldn't be asking if you think tipping them off if you believe that asking them for ID would tip them off that you're filing a suspicious transaction in that particular scenario. At the bottom of the slide, those are just some examples of suspicious transaction indicators. There are a number of other ones on FINTRAC's website and also in the CREA materials, but I thought it would be helpful as a reminder.
So that's a quick presentation on FINTRAC and the new regulations that came out February 1st. We'd like to turn now to the Canada's anti-spam legislation, which comes into effect July 1st of this year. Many of you may or may not know, but Canada is the only G7 country or G8 country not to have any anti-spam legislation. And currently there are about 100 countries around the world that have some sort of anti-spam legislation. So to a certain extent, we're playing a bit of catch-up in Canada. You can see from the slide here that this has been a long process. In fact, the slide doesn't really take you back to the beginning, which is actually in 2005, 2006. But CREA really engaged in the process in 2009, sat through committee hearings through both houses of Parliament, and made significant amendments and changes to the legislation that favor realtors. In particular, David's going to talk to you about one that has to do with referrals and getting consent or having implied consent to approach someone to whom you've been referred. So the way it would work is if David is a good friend of mine and I've got a realtor I've been dealing with, I tell my realtor that, hey, my good friend David is looking to buy or sell a property, can you get in touch with him? So under the amendment we won, that is now legal for the realtor to contact David directly and say, your friend Randall said you're interested in a property. I thought I'd give you a quick email to let you know I can help you. What's frustrating about that is originally, as proposed, the government had made that illegal and against the law. And it's one of the last amendments we won. We got about 10 different amendments or changes to the legislation. That one was the last to come in the last 7 or 8 months. So David's going to take you through the fundamentals of the legislation, which center on consent and the person giving consent to receive an email.
So the whole idea, as Randall mentioned, is around getting consent from recipients to send them an email. The idea really was based around the idea of giving Canadians control over their inboxes, and it's based around the concept of a commercial electronic message. Now, in order to be a commercial electronic message, it needs to have three components. First off, it needs to be commercial. So it needs to encourage participation in commercial activity. Some examples of this in the real estate context would be promoting a listing or an open house, promoting your sales history or records. Secondly, it needs to be electronic. So it needs to be sent to an electronic address, either an email address or an instant message address, telephone, or other account. There are two exceptions to this right now. Voice and fax messages are excluded because they're currently covered under the do not call list. And thirdly, it needs to be sent to or from a computer system located in Canada or to a country without anti-spam legislation. So if you're sending a message to somebody in the States, you basically need to comply with their version of anti-spam legislation and not Canada's. So after July 1st, when this comes into force, there are 5 questions you should be asking yourself. First is, are you even sending a commercial electronic message? If it's not commercial, it's not electronic, it's not covered by the new anti-spam legislation. The second thing you want to ask yourself is, do you even need consent? There are a number of exceptions, which we're going to talk about. Do you have consent? So consent can either be expressly given to you by somebody, or it can be implied according to a number of scenarios in the legislation. Fourthly, you have to provide prescribed contact information, and I think you'll see when we get to that point that you're probably already doing it with your email signatures. And you also need to provide an unsubscribe mechanism. So we'll just now cover the commercial electronic messages that are exempt, and I'm not going to cover all of them, just the ones that are most applicable in the real estate context. Exempt commercial electronic messages, even though they're commercial, you don't need consent when sending them, you don't need to provide your contact information, and you don't need to provide an unsubscribe. So the first one is around a personal relationship, and basically what this means is that you've had direct, voluntary, two-way communication, and it's reasonable to conclude that you have a personal relationship. What they mean by reasonable to conclude is that you share interests, experiences, opinions, and information evidenced in previous communication. They're going to be looking at the frequency of the communication you've had with that person, the length of time since you last communicated with them, and whether or not you've met them in person. So one way you may want to look at this is, have you ever spent time with them, and to what degree outside of work? The second component is around a family relationship. And what this means is, are you related to the recipient through marriage, common law partnership, or any legal parent-child relationship, and you've had direct, voluntary, two-way communication with that person? If you meet those tests, those would be exempt communications under CASL. Also, in terms of the second point, an inquiry, this may be helpful in the realtor-to-realtor context. If there's a realtor who's selling a property that you have a client who's interested in looking at it, it's perfectly okay to make an inquiry. That would be an exempt communication under CASL. Also, in the FSBO context, if you have a client who's interested in buying a house that's been posted on a for sale by owner website, if the for sale by owner individual puts their email contact on the website, it's perfectly okay to contact them if you have a client who's interested in looking at that house. Where you'd be offside is if you were soliciting if you were making your services known to that person in terms of soliciting their business. Some other exemptions which may be helpful if you're using BlackBerry. That also, the BlackBerry Messenger platform is also exempt. You can email people or message people through BlackBerry Messenger. That's what they mean by certain messaging platforms and accounts. The one question that comes up that's helpful maybe to cover is around Facebook and Twitter, and how you deal with the messaging functions of Facebook and Twitter. Basically, if you're messaging someone, even though they've accepted you as their friend, that's not enough to meet the personal relationship test. You basically would already have to have a personal relationship in order to send a message to somebody through Facebook or Twitter. But what you can do is you can post your information on the Facebook wall, or even through the Twitter. Even on your just main Twitter feed, that would be perfectly okay, because you're broadcasting, you're not actually sending somebody a message in those circumstances. Now I'm going to talk a little bit about when consent is not required. In these circumstances, you'd have to provide your contact information and the unsubscribe. That does apply. And the one that's most applicable to the real estate context is the one that Randall touched on earlier around third-party referrals. And this slide basically illustrates how that would work. So the person who's making the referral to you would have to have a personal, family, or business relationship with both you and the recipient of the message, the person who's being referred. And if that is the case, you'd be able to send one message. All you'd have to do is ID the person, mention the person who provided the referral to you in the message, and you'd have one opportunity to contact them. From research we've done, we figure this is going to save about 3.4 million email contacts each year in our industry alone. So there are two types of consent. The first one is getting consent by having implied consent. The first component of this is around the existing business relationship. And basically what this means is that you've done business with somebody in the past 2 years. Prior to Korea's lobbying, it was 18 months, but we pushed for it to be longer, and we ended up with 2 years. So you'll have 2 years from the end of any written contractual relationship, so a listing agreement, a buyer agency agreement, the purchase of a property. The clock will start ticking 2 years on the expiry of that agreement. You can contact that person until they withdraw their consent within that 2-year window. The second aspect of this is if someone makes an inquiry, you can contact them for 6 months without getting express consent. The second aspect of this is around the existing non-business relationship. And this is more applicable in the club, association, and charity context, so more for boards and associations. But both existing business relationships and existing non-business relationships are grandfathered for 3 years after the legislation comes into force on July 1st. So basically what that means is if you had a buyer agency agreement with somebody 10 years ago, or if someone made an inquiry 15 years ago, if you've got them on your email list, you can contact them for 3 years until July 1st, 2017 without their consent, which gives you an opportunity to preserve your email list and ask for express consent during that 3-year window. The last two components around implied consent are more applicable in the business-to-business context. If someone publishes their email on a website or provides their email to you, you can contact them, but it has to be related to their official or business capacity. So probably more applicable to the commercial realtors rather than the residential realtors, those specific exemptions. Now I'm going to talk a little bit about express consent and how to get it, how it can be obtained. There are two ways you can obtain express consent, either verbally or in writing. That may sound obvious, but believe it or not, when the government first published its some information around this, you could only get it in writing back then. So we really pushed hard on that to ensure that consent could also be obtained by realtors verbally. And the end result is that that is allowed. So when you're getting consent, express consent, you first want to tell the person the purpose, why you're asking for their consent. You need to ID the person seeking consent, so yourself, or if you're getting on behalf of somebody else, you need to mention their name. You need to provide prescribed contact information. And what they mean by this is your mailing address and either a telephone number, an email address, or a web address. Believe it or not, when we first saw the draft requirements, they had wanted every mailing address, every telephone number, email address, and every web address that you send your commercial electronic messages through. So we really pushed to limit that, and the end result is that you probably are already doing it. It can be satisfied through your email signature. You also need to inform individuals that they can unsubscribe. And you need to ensure that when you're asking for consent, that you do it in a way that qualifies as express consent. So for example, you can't pre-check a box on it if you're doing it through the web. You can't pre-check a box on a form. The CRTC has expressly said that you can't do that. And finally, because this piece of legislation is going to be complaint-driven, really important that you retain evidence, so either a simple diary or a database, just to ensure that if somebody ever makes a complaint, you've sent them a spam message, that you can back it up and say, well, no, I got consent, and I got consent on this date. So in terms of what information needs to be in each commercial electronic message that you send, you need to provide your name and your mailing address and either a telephone number, email address, or web address. And then you also need to provide an unsubscribe. And what they mean by this is that you have to make sure that it's displayed clearly and prominently, so it can't be in small font. It needs to be able to be readily performed. It needs to be simple, quick, easy to use. Ideally, using the same method that somebody receives it in. So if you're sending an email, they should be able to unsubscribe by email. It can impose a cost on the consumer, so probably not applicable in the real estate context, but you can't have it behind a subscription-only website, for example. And it needs to be done within 10 business days. So some ways you can go about doing this: you can have an email, a link in an email that takes a user to a web page where they can unsubscribe, or you can set up your Outlook so that somebody can just very easily click on a message at the bottom, and it would send a message back to you with unsubscribe in the subject line. That's another way that you can meet that test.
Thanks very much for your attention. 2 quick points before we move to the question and answer period. First, hopefully we don't have to do this again, and you can help us so we don't have to do it again by joining the Realtor Action Network. It's a unique tool to Canada. Realtors are the only ones who have access to it. We're the only association that has a tool like this in Canada. What it is, it's basically a government relations tool that allows us to lobby the government on your behalf. And our strength as a national association is our membership. 110,000 realtors across Canada have a great amount of influence and say in what happens if they can mobilize their voice as one. So right now we only have 4,000 members on the network. We'd like you, if you can, take the time to join. What's going to happen is you'll put in your name and address, and the site will be populated with your MP's name. And this is a tool we use if we're going back to them on FINTRAC, and we would have really appreciated having it up and running for the referral amendment on anti-spam. Unfortunately, we didn't. So what we would do in that case is we would put out a notice. You would all get notified that there's something on the Realtor Action Network that we'd like you to take action. We'll pre-populate it with a letter or a correspondence to a politician. So all you really have to do is take 2 minutes, put in your name and address. It'll say who your MP is, and then you can be among the most up-to-date on what's going on in Ottawa. And if we need to call on you to change government policy or regulation, we can do that. And hopefully we're aiming to get 10,000 members. So if we issue a call to action, we can get 4,000 or 5,000 responses to try and move government minds, move policy thinkers. The last thing I want to say before we get to questions is that there are several government departments involved here, and the application of the guidelines under FINTRAC or the regulations under anti-spam have not all yet been finalized. The interpretations that go with those haven't been clear. So we probably be able to answer 90% of your questions, but one of the unique benefits to us in doing these presentations is that you give us insight into scenarios that we haven't thought of or the government hasn't thought of, so we will go back to them and seek clarification. But I think we'll be able to handle most of the questions. But just so you know, both are evolving files, and both are ones we continue to engage in. In fact, in the last day or two, we've had a couple really good questions from TREB members that we're going to take back to the government and take back to our lawyers and see if we can sort out. So if that's the case, we'll get back to you through TREB. So thanks for your time and patience. We'll start right now with the questions. The first one has to do with the brokerage requirements for FINTRAC. What documents does the brokerage need to have on file? I think we need to distinguish between what we've talked about today and existing FINTRAC rules and regulations that have been there for about 7 years. So what we're talking about today presumes you have the basis FINTRAC compliance in there. If you don't, you can go on Realtor Link and all the documentation is there about how to comply. But just to quickly go over it, you need to do a risk assessment of your business, you need a compliance officer, you need to offer some training, and then when you do business with a client, you'll need to ID them among a few other things. But those have been in place for 7 or 8 years now. What we're talking about today are the new changes to the guidelines brought in February 1st. I hope that answers the question. David, if you want to add to that.
Yeah, just to build on what Randall's saying, I think it's important to maybe direct you to the new resource that CREA has prepared as a result of feedback that we've gotten from members and and also some feedback that we've gotten from the government. It's a FINTRAC Office Compliance Manual. It's available on Realtor Link. It quite frankly walks you through step by step of the various requirements. And the benefit back to brokerages is that if it's filled out and tailored back to the brokerage's business, it can be used to satisfy a long-standing FINTRAC obligation of a documented policies and procedures manual. So I'd really encourage you to check that out and download that document.
You want to take the next one?
Sure. So the question is, does anti-spam, do the exceptions include agents between brokerages, i.e. can we send our listing information to other brokerages without consent, or we have exchanged agent lists with the brokerage? So I'll answer this question in part, and part of it we're going to have to take back and get some additional clarification around. There is an exemption for if somebody conspicuously publishes their email address and it's relevant to their business. So if realtors have been publishing their email addresses on your website or their website, and they're doing it themselves, they're giving consent from that perspective, then yes, it's absolutely okay. The second part of the question I'd like to take back. It's actually, quite frankly, similar to some of the questions we got yesterday at our broker session, and we are working through it. But there is a clear exemption for either if another agent has provided their email address to you, or if the agent has published their email address on their website. If it's dealing with real estate, I would assume that bar has been met in terms of an email that relates, that's relevant to their business.
We've got a couple more on anti-spam, and we'll continue with this, and then we'll move back to FINTRAC. Following on the last question, what about promoting commercial activities but only as informational through a monthly Market Watch report? There's actually two parts to that answer. If you're promoting commercial activities to a list you have, you may or may not, depending on how you got those names, they may or may not be exempt for 3 years. If it's someone you've done business with before, they are exempt. If it's someone who got on that list through a contact you had privately and didn't give you consent, then there's a challenge there, and it may be offside with legislation. David, do you want to add to that?
Well, if you're not, it comes down to the content of your email. If you're promoting a commercial activity, then it would be captured by Castle, with the exceptions that Randall just mentioned. If it's not a commercial activity, if you're not promoting a commercial activity, then it would likely fall outside. But we're a bit hesitant to provide a specific answer on this, because it really would come down to really being fact specific. So. Another question on anti-spam is how do you need to retain evidence of oral consent? The short answer is yes. Oral consent is in the law. You're allowed to get it. You can keep it as part of a database, an Excel spreadsheet. You can keep it as part of a diary. But all you need to do is something to the effect of saying, on this date, spoke with so-and-so by phone and received oral consent to contact them electronically. Moving back to FINTRAC, we have a question: define high-risk countries. Is there currently a list that is updated frequently? The good part of the answer is yes. The bad part is that there are several lists. So it's a bit of a challenge, and it's one of the issues where we continue to work with government to get a readily available, clear, and complete list. There's a bit of infighting going on between government departments, and we're trying to push for a solution that makes it easier for all of you. But if you look at our compliance documents that David spoke about earlier, there is a link to one of those lists, and it lists all of the relevant countries. Another question around, is FINTRAC required for leases? The answer to that is no. FINTRAC only is required for when you're acting as an agent for the purchase and sale of real estate. So with leases, it does not apply.
Back to an anti-spam question. If explicit consent was received to keep in touch in writing, would this continue for always until revoked? If you get explicit consent to contact them by email and you have a record of that, yes.
And if you do it by the way that they ask you to get express consent?
Yes. It's forever.
A question here about, did you mean in terms of anti-spam when asking for consent or in each email, that you have to put your address, email, and telephone number in all communications. So the answer to that is no. You need to provide your name and your mailing address, and either a telephone number, email address, or web address. So quite frankly, you can just provide your mailing address and your telephone number, or your mailing address and your email address. But I think the reality is, from a lot of the communications that I get from members, most are already doing this. They already have it on their email signature already, so probably already being met.
Well, there's a question, I think it's FINTRAC related. I don't think it's anti-spam. Will all brokerages be required to have their own policies? Yes, when it comes to FINTRAC, because every brokerage has a different book of business. Your types of clients, the types of properties you're selling, to whom you're selling those properties, they're all different. So FINTRAC requires, and has for about 7 or 8 years now, that you do a risk assessment of your own brokerage, and you can use the policies that are outlined in the guidance document as a guide, but you can also adapt them to so there's lots of examples in there, but you can also adapt them to your brokerage. But yes, if FINTRAC calls and they're looking for your compliance regime, it will have to be brokerage specific. It can't be generic, but as David said earlier, the documents on Realtor Link walk you through a step-by-step way to do that. Go ahead.
The question about how to define being physically present, what length of time over what number of months. Physically present basically just means you're dealing with them in person.
Right.
So if you're dealing with a buyer in person, as opposed to a buyer that you're dealing with on the phone and selling them a property, you've actually never met them. Physically present basically means you're dealing with a buyer in person.
Face to face.
Face to face.
We have another question about BBMs and anti-spam. Does the same rule apply to Apple Messenger or to Skype? This is one of those peculiarities of Canadian legislation where the government seems to have done something for BlackBerry. We're not quite clear, but it seems to be BBM specific. We've had this question from a number of other people. We're going to take it back to government and say, where did they draw the lines? Because it seems to be a bit of an afterthought, and it's not clear to us either what sort of messaging platforms they intend to include or exclude.
Question here around when a prospective client requests verbally for automatic email listings, do we need his written consent? So if someone's made an inquiry, you're going to have 6 months to contact them. During that time, you will need to get express consent. In that conversation, though, you could ask them, if you follow how to get express consent, you could ask them for their express consent during that conversation, but you don't have to. You can rely on the inquiry provision and then get their consent later on if that's what you choose.
But based on the question here, if they verbally expressed an interest in receiving email listings, you might as well ask for their consent. Definitely. To contact them by email. You can kill 2 birds with 1 stone. Aren't the email addresses of TREB salespersons published on the MLS system?
So this question actually came up yesterday. This is something that we are going to be looking at and getting back to TREB on in terms of whether there is a way to whether that does fall within the definition. It's a little bit unclear to us, but we are committed to getting back to you and determining whether that is in fact allowed.
And to be clear, it's unclear to us because it's unclear to the government. They haven't contemplated the level of detail in rolling out the legislation. So these are all questions that they're interested in receiving so they can provide the correct guidance. Moving on to about email. When you say the server receiving the email has to be in Canada, the sender, not the server, sorry, I don't know if we were clear. So if you're sending to someone in Canada, from someone in Canada, you follow the Canadian rules. If we're sending an email to gmail.com, well, if the person is in Canada, you follow the Canadian rules. It's not based on the email address. It's where the person physically resides in terms of following the law. So if you're sending someone you know they are in the U.S., they have to follow the U.S. rules, just like if an American were sending into Canada, they have to follow the Canadian rules. Go ahead.
The question comes from somebody who's been using their brokerages or franchisors' system, sending email to their clients and customers. On that system, there is clearly stated if the recipient should unsubscribe. There's an unsubscribe feature currently. Due to the recent CEM, do I need to send a new email to seek their consent? So the fact that it's an unsubscribed doesn't necessarily mean that consent has been obtained. If consent has been obtained previously through, and it's compliant with Canada's Privacy Act, the PIPEDA is what it's called, or PIPEDA, then those consents are grandfathered. So the fact that someone has an unsubscribed, unfortunately, doesn't mean that you can continue to send email. But if it's really a question on how the consent was, or if consent was gotten in the first place.
What FINTRAC paperwork is required from a trust company acting as a POA for their client and mine?
Yeah, we're going to have to. This is a question where we're going to have to take away and do some additional digging. But again, happy to loop back through TREB on that.
Another FINTRAC question: what if you know someone for a number of years, but now is not present, and we are dealing on the phone? How does that affect the information required to be collected? Well, if you've collected the information initially, or you personally know this person and have seen their ID, and it's their first time doing business with you, I think you're okay.
If you know them already, if we're talking specifically around the ID provision, if you've already collected their information, if you already have their ID on file, you don't have to ask for it again. If it's the first time you're dealing with them, you do have to ask for their ID. But I mean, quite frankly, we talk about this all the time because this is a legitimate question that comes up quite often around, if you know someone, you have to ID them. I mean, Randall and I on our way down here, I think we were ID'd 2 or 3 times, once when we were in the airport, once when we checked to the hotel, probably be ID'd again on the way home. You basically are just asking for their ID, taking down the records, and if it's someone you know quite well, hopefully they don't have a huge issue with it.
There's a question here about spam. Can there be further clarification on not promoting commercial activities but purely informational? For example, would be articles that link on mortgage rates or economists report on housing activities. I think with respect to anti-spam, the key point you have to understand is it doesn't matter the subject matter. It matters about your relationship and consent. So there are exemptions based on family or a social relationship outside work where you don't have to get consent. But the subject matter of the email isn't the critical point. The critical point is the nature of your relationship and whether consent is given. So the exemptions that David went through in the slideshow give you examples where you don't need consent. But for every other email, you need consent. You can get that consent orally or in writing, but it doesn't matter the subject matter of the email.
If you're intending to promote a commercial activity,
yeah,
that's really they're going to take a look at the content from that through that lens, and you could have a completely informational email, and you could have one commercial component, and that could be enough to trigger the CEM. So Randall's absolutely right. You want to focus on whether you have consent. Now,
in this instance, though, if you're sending out this information to people you've had on an email list for a long time, we've got a provision that says those lists that you've accumulated over years or decades are grandfathered, and you have 3 years to seek consent. So in that case, it's not the content of the email, it's the list that you've had, that you've built up over time. And you have to get consent still in this instance, but you have 3 years to get from July 1st, 2014 to July 1st, 2017 to get the consent you require. Rules for social media. Yeah, I don't know if we spoke about that with respect to the anti-spam legislation. So there are rules governing social media. David can take you through them.
Yeah, so basically social media is a couple of, if you're looking at sort of Facebook, Twitter, LinkedIn, those seem to be the major ones that are used by our members. There are 2 components to social media, and really important as well to understand the rules of the actual provider. I'm only going to talk to you about how CASL applies to them.
CASL is the anti-spam legislation. Yeah.
So with respect to Facebook and Twitter and even LinkedIn, they do have messaging platforms built in, but they also have, as you know, the ability to broadcast out either on your Facebook wall or your Twitter feed, or LinkedIn has a similar mechanism. The messaging component, that's really where where you could fall a bit offside. The broadcast component, the wall and the feed, you're probably likely is not covered by the spam legislation, but the messaging platform is. The question that comes up often is, if someone has accepted your friend request on Facebook, is that enough to be able to send them a commercial message? The answer, unfortunately, is no. But if you already have a personal relationship with them, by the definition of personal relationship, which is much deeper than accepting someone's friend or contact information on LinkedIn, then the personal relationship, you could use that. You could also rely on some of the other exceptions that we talked about in the legislation.
Yeah, we should be clear. A like on Facebook does not constitute consent. If you want to send them a message, you have to either have a relationship outside of work and be friends with them, but just liking you does not give you consent to contact them. This is a good question about email lists.
I got their email through listing, door knocking, buyers, and people who have requested information through my websites. Hence, no need to take their new consent, correct? Well, I mean, if someone's requested information through your website, you would have a 3-year period because they made an inquiry in the past. Door knocking, buyers, again, that would be a buyer would be a contractual relationship in the past. So again, you'd have that 3-year window. But during that window, you would have to ask for consent again. So you'd have 3 years to do it, and then once you have that consent, you can certainly have it for forever. And
going forward, if you've established some of these lists by door knocking, as you said, or meeting people in person, you can get their oral consent as long as you document it when you have that interaction with them. So that can be, you can get that consent in your interactions with them, and that consent is good forever as long as you document that on such and such a date you met with such a person and they gave you consent.
And inquired, exactly.
Yeah.
Do we need to print all email messages of a transaction to keep on file for FINTRAC? So that is one way that you can meet that requirement. What they're looking for is the messages that show that you've done something on customer due diligence, that you've actually put that into practice. So you don't need to certainly preserve all of the emails, but the ones that are relevant to customer due diligence, the questions you're asking around that, whether you're asking for additional questions to get at something or to get more information, that's the sort of stuff you'd want to keep on file.
Yeah, they're not looking for every piece of correspondence you've had. They're looking for things that help show that you've done the work you need to do, that you've, if it's the second or third transaction with someone, that you've done the customer due diligence things and said, so still the same place, still in the same business. If you get answers to that, fine. Those would be sort of this emails you'd want to keep. This next question, I know this is Realtor specific. Do you know, or of your own knowledge, if this is applicable to other professions, mortgage consultants, etc.? I assume you're talking about anti-spam. If so, absolutely. It's applicable to everyone. There are no exemptions. Well, that's not true. There's one exemption for political parties. So those emails I get from every political party, I unfortunately won't be able to get rid of. But this applies to everyone in the country. So they will have to seek consent. In fact, there's been some stories in the newspaper in the last little while about this. And I even got an email from an organization I belong to just yesterday asking for my consent going forward to email me. So yes, it applies to everyone. Is there such consent form produced? Is there a consent form produced on web forms?
So I assume this again applies to Castle. There's actually consent anti-spam. There's actually consent ways you can get consent. Examples of that in Korea's new materials, which are on Realtor Link. So it's just recommend going to Realtor Link to download those on Canada's anti-spam legislation. Consumers attending an open house, how can we approach them for their consent? Well, one way that you could go about doing it is having a form. I know a lot of agents have sign-in forms at open houses. You can put your consent information on that form and get their email address. And so long as it's done in a way that that's applicable to that follows the act, then you're perfectly fine. There's some examples as I said, in the Korea's materials.
Thank you very much for your time, patience, and all your questions. I hope we got to them as best we could. We will be providing some clarifications to questions that were asked and briefings across the country, and we'll provide them to all boards and associations. So really appreciate your time and patience and engagement in this file. Thanks very much.